car crashes, defective products, dangerous drugs, injuries, and abuse. Across the state of Alabama, the attorneys, proudly sponsored by the law firm of Hollis, Wright, are here to serve you. Your tough legal questions answered by our experts with the attorneys of Hollis, Wright.
Good evening. This show is all about understanding your rights in the workplace. Welcome to the attorneys. You've made the best decision to get the best legal advice by tuning into the show. I'm Art Franklin, your host, along with, of course, Josh Wright, the managing partner at Hollis Wright. We've got a very special guest. We're so glad to have Kyra Fontenot with us for this show. Good evening to you.
Thanks for having me.
You know, and your specialty is not a specialty that every lawyer does. Like, you really have to know this area of the law in the employee setting, how to handle folks that have disabilities or need accommodations. I mean, how did you get into this area of the law? Because, I mean, you know, like, I would not know how to navigate my way around, you know, this in a courtroom in any respect. I would have to come to you to go through this. How did you get into this area of the law?
Yeah, so I started off actually as a manager in a workplace and decided to go back to law school because I thought this was, you know, something that I was actually interested in. So I'm one of the rare people who went to law school knowing what kind of work they wanted to do. And so I came out and I actually worked on the defense side. So I helped employers get out of trouble when they were being sued by their employees, and found that I prefer actually helping the employees to helping the employers.
You know, I came from that background too, because I was a defense lawyer before I was a plaintiff lawyer, and I feel like that made me more well-rounded. You feel the same way?
Yeah, I think oftentimes if you can kind of see the other side and how they view things, I think it's a lot easier to help your clients kind of navigate the process because you understand where the pitfalls are a little bit more so than somebody who's just only come at it from one side of it.
Talk to me a little bit about your practice. Are you focused, you know, exclusively on employment, or do you do some other stuff too?
Yeah, so I actually do both employment and civil rights laws. So I also work on police misconduct cases, anywhere the government has stepped on your rights or an employer has stepped on your rights. Those are the kind of cases that I like to take on.
Now, we get this question all the time, and the question is, hey, you know, I'm an at-will employee, which means they can fire me for any reason. Like, I get those calls weekly. And that's not necessarily the case, is it?
Yeah, I think that's a common misconception that they can fire you for any reason. I can say, I don't like your green tie, I'm going to terminate you. Well, they can terminate you, but they can't terminate you for some of the reasons that are illegal. They can't terminate you because of your race, your sex. They can't terminate you because you asked for your workers' compensation rights, or if you were asking for your overtime to be paid properly. There are lots of reasons why an employer's decision might be illegal, but you have to find out first by asking a lawyer oftentimes, because they're not going to just tell you.
And, you know, Art and I talked a little bit before we started today. This show's really about disability and accommodations. That's kind of a subsection of other shows that we've done with you before, because I know you've been on before. But, you know, accommodations in the workplace is kind of a separate area of the law, and it sounds like something that you've gotten into that is super relevant for the viewing audience, pregnancy, other disabilities, etc.
Yeah, I think it's often important to understand that just because you're at work doesn't mean that your employer has complete control over the environment. They have to provide accommodations to you if you qualify, and you have to speak up and ask for those and make a clear request for an accommodation. But if you do, there are often times when, you know, they can tweak the environment so that you're able to work. There are a few different ways. A lot of times if you have an accommodation request because of your disability, if you're pregnant, or oftentimes if you're just sick for more than 3 days, you might be entitled to a time off work accommodation.
When you talk about the accommodation side of it, there are requirements in terms of making sure it's safe, but training and other regulations are important as well for that employer, right?
That's right. If you go to an employer, one of the first things they should always do is train you on your rights in the employment context. You should see things that say, like, we won't discriminate against you, there's no harassment, and that we will accommodate you if we need to because you have a disability. Oftentimes they may kind of gloss over those days, but those are very important days and you should be really aware of those. Look for that handbook and find out what they're willing to do for you.
What do you see in your cases? Like, what types of accommodations are we talking about that someone could make in the workplace that would be appropriate for someone who has a disability or requires the accommodation?
You know, it really varies based on what kind of employer they are. The larger the employer, the more extensive the accommodations they might be required to give you. So what they're supposed to do is look at what your needs are in order for you to be able to do the essential functions of your job, and then interact with you to determine what's available. Could be a keyboard, a different kind of keyboard, could be a larger monitor, could be a change to the way your workplace is laid out. It just depends on how big the employer is and whether it's reasonable.
And Kyra, every employer is different. Can they deny me accommodations if I'm that employee?
If you are unable to do your job, even with the accommodation, they can say no. If the job would be made dangerous because you were doing the job with the accommodation, they can say no. But the first thing they have to do is engage with you with an interactive process where you say, well, you know, I'd like this thing. And they say, well, I can't give you that, but I can give you this. It has to be a give and take. It's not just no and we're done. They have to talk to you first and figure out maybe if there is a way that they can accommodate you.
And I know people probably call you and say, you know, I feel like they're not assisting with an accommodation or a disability that I have. Is your first recommendation always, well, we need to evaluate litigation, or is your first recommendation sometimes, hey, look, here's what you need to do to go talk to your employer to learn and start that dialogue? It sounds to me like a lot of this is based on just good communication between employer and employee.
The first step in every employment case is putting the employer on notice. If they don't know what you need, you're never going to be covered under the law. And it is always on the employee to make an effort to initiate the process. They don't have to generally notice that you have a problem and ask for it. And a lot of times you can get in trouble because you did need help and you didn't ask for it, and then they discipline you because you weren't able to do the essential functions of your job when an accommodation request might have helped you to do it. So you do have to talk.
She knows her stuff.
She does.
I mean, this is why we bring experts. You know, we've said for years on this show, and Kyra can appreciate this, like, you know, our firm is not an expert in all areas, right? This is why we do this show. We bring people on that are experts. And oftentimes, I'm on a lot of the emails where we get a case in that is employment related, and I will see our coordinator will send it directly to her. I'm copied on those, and I'm like, man, I'm so glad that we were able to get this case over. And whether it develops or not, you know, that's up to each individual case. But the point being is, there are areas of the law where you got to have an expert in it, and Kyra's the expert in this area of the law. We're getting ready to go to break, but when we come back, I want to talk a little bit about disability generally, and really what qualifies as a disability, because not everything qualifies as a disability. Not everything qualifies as you need an accommodation, but I want to unwrap that just a little bit when we come back. But I'm so glad you're on today, because I think this is super important for the viewing audience. Thank you.
Yeah, disability. Go ahead and put a pin right there, because we're going to talk about that when we come back. But we also want to remind you that we've got a QR code right there on your screen. All you got to do, take your phone out, scan that QR code. It'll take you directly to Hollis Wright. You'll be able to see some of the team members. You'll be able to fill out a form and ask your questions. You'll also be able to click on some of the social media sites. Call the number too if you need them, 1-844-LAW-TALK. We're taking a break. We'll be back right after this.
I'm Josh Wright with the law firm of Hollis Wright, a personal injury law firm, and thank you for watching The Attorneys. We hope you, a friend, or a loved one never needs legal counsel for a case. But if you do, the goal of the show is simple: to provide answers and legal counsel when you need it the most. Your call to the show is free and off air. So if you have questions specific to the show or related to other accident or injury topics, call, email, or text us. You can also follow us on Facebook, Twitter, Instagram, and YouTube, or go to hollis-wright.com and click on the Contact Us button. We know your time is valuable, so thank you for spending it with us and watching The Attorneys.
The Attorneys, proudly sponsored by the law firm of Hollis Wright, are here to serve you.
When we started the show in 2011, my goal was to do what our firm does best. Help people answer questions related to real-world legal issues they have in their lives in a way that's not intimidating to talk with a lawyer. If the issue is important to you, it's equally important to us, and we're ready to talk with you at no cost.
Yeah, oftentimes people are confronting various legal issues in their lives that really run the gamut of a lot of different legal practice areas such as bankruptcy, criminal law, civil law such as personal injury, divorces, domestic relations. And to be able to have a show once a week that covers those practice areas and answers people's questions in those areas, that's really the main objective of the show.
We use the resources of the many lawyers at our law firm to create a plan that has a lasting impact for each person that calls or texts. And we also give back to the community at the same time. We are here to serve you, the viewer, each week on The Attorneys.
At Hollis, Wright, we pride ourselves on having a bedside manner that's second to none. That means we listen more than we speak, and we return calls to current and potential clients. Our attorneys are standing by right now. At Hollis, Wright, your result matters.
Accommodations in the workplace, what you should know your rights. We are the attorneys, and we are talking about that very subject right now. We talked about disability, Josh, as we were heading to break. We wanted to kind of tee that up, Kyra, for you as we came back. And Josh, that was an important point you wanted to point out.
Yeah, I think so. Not everything qualifies as a disability, and I do think it's helpful to unwrap that just a little bit so that people understand, you know, what could and what could not qualify.
Yeah, so it's not to be confused with the type of disability that would get you Social Security disability. Right. A disability is anything that substantially limits you in any major life activity, and that's a kind of legalese way of saying if your body doesn't work the same way as other people's bodies and it hinders your ability to do it the same way everybody else would, then it's a disability. So it could be you have diabetes. It could be that you are missing a limb. It could be a significant visual impairment, not just needing glasses, hearing impairment. There are a number of things that could be a seizure disorder, anything that, even if you're living with it and managing it, that limits you as it relates to your ability to perform the essential functions of your job.
And, you know, one of the things we really haven't talked about is in hiring individuals that already have that type of disability, like there are certain parameters of what someone can and cannot do related to hiring. I mean, can you discriminate against somebody that has that disability in the hiring process, or do they have those rights to be able to be eligible for the same jobs that someone who doesn't have that disability would have?
Absolutely. They need to be considered for the position, even if taking the position will require an accommodation. So if they're excluding individuals because they perceive them as unable to do the work, that's not okay. There needs to be a job reason that they can't do the position. Now, if you had something where you were working in heavy machinery and you had severe seizure disorder, that might not be the best fit for you. They may not have to accommodate you there. But if it's something where you come into the job and you need a different keyboard, or maybe the chair height needs to be different, or maybe you need a ramp to come to work, they cannot exclude you for that.
Kyra, if I can just ask you this question, because sometimes there are violations. Sometimes the company doesn't do what they should be doing. And as an employee, I want to report that. What kind of protection do I have should I report it?
That's a great question, because that is the most important way that we often are able to affect change in the workplace, because you have to complain and you have to ask for the accommodation to put them on notice to get the protection of the law. And so the law actually looks to retaliation as one of the more serious violations that you could have of the law. So if there is a person who asks for an accommodation or presents with a disability and they're discriminated against after they've spoken to HR and given them notice of their needs, then there's a new cause of action for the retaliation for seeking the accommodation or for complaining about discrimination because of their disability.
And I would imagine, like we see, for example, in the workers' comp setting, sometimes those claims can be more valuable than the underlying claim itself for not hiring that person or for terminating that person for that disability or need for accommodation.
Absolutely. Sometimes you might not be entitled to the disability accommodation. Maybe what you're asking for is unreasonable, but if they terminated you because they did that, well, now you've got this humongous claim with damages because you lost work, and now you have to find a new job, and you lost your insurance benefits, and maybe you have mental anguish related to that. And so those claims are often easier to prove than the fact that they discriminated on the basis of one of the protected categories.
Take me through this. Someone comes to you, they sit in your conference room. How do you crank these cases up? Like, what is, because it's uniquely different than what I would do on the personal injury or product liability side. How do you evaluate these cases? And is it like, I need to see your handbook first, I want to see your employment contract? Like, how does that work? Because I would think your evaluation's totally unique from what normal personal injury lawyers would do, for example.
Absolutely. It's a much more fact-intensive inquiry. And what we're looking for is intent. What were they thinking and what was motivating people? So it's a lot harder to prove that somebody intended to discriminate and they weren't just being, thoughtless, right? And so what we're really looking for is that you meet one of the qualifications for being protected under the law. In this case, we're talking about maybe being pregnant or having a disability, that you've requested that accommodation, and that after that, some adverse employment action happened. Did they fire you? Did they stop? Did they cut your hours? Did they demote you? And then, what reason did they give you for doing that? And how do I prove that that reason was false? And so we're really looking for lies. And so it is much more, I can't really draw a diagram for these cases. I have to be able to figure out how to prove that someone was lying about the reason they did something to you.
It's interesting, and sometimes you're going to have other employees that gather information and can help the case too, that get involved.
And Kyra, you mentioned pregnancy. What kind of accommodations are we talking about for a pregnant woman?
Well, a pregnant person can come into the workplace and ask for accommodations so they can continue their job all the way up until the time they deliver, but they can also ask for accommodations for the time when they're trying to get pregnant. Let's say they have fertility treatments, or after they're pregnant, if they want to pump breast milk during the workday. So there are accommodations that you can seek for being pregnant and for the before and after part of being pregnant as well.
Let me follow up on that. What kind of accommodation? Are you talking about a separate room or?
Okay, so if you're looking for time to pump milk because you want to feed your baby, yes, there has to be a separate room. It has to be private. Cannot be a bathroom. That's not a sanitary place to go pump milk. You don't want to eat in your bathroom.
No.
And then they also have to give you time, paid time, to go pump milk during the day, and every few hours. It's not just one time.
Yeah.
So, and that's in addition to your lunch break.
Talk a little bit, though, related to just pregnancy policies in general. I know that's kind of a big issue, and at our firm, for example, we got some of the women involved in helping us craft the policy that we have now to make sure that we were accommodating their needs, and we wanted to encourage people to have kids just like everyone else does. And so are there like certain requirements if you are an employer of 15 or more versus 50 or more, or kind of how does that work generally? I mean, are you guaranteed time off no matter how big your employer is once you have a baby or not?
So the size of your employer, it does matter in whether or not the accommodations need to be made for pregnancy. If they are 15 more employers, so the vast majority of people are working in a workplace that has more than 15 employees, they do have to make accommodations. They could be accommodations just like disability accommodations, that would modify your workplace. Maybe you need a different chair. Maybe you need time off work. You can ask for that as a pregnancy accommodation. And then you go through that same reasonability analysis that we would under a disability to say, well, can this company afford to do the things that we need to accommodate this pregnancy?
When we come back, because I know we're getting ready to go to break, Art, I want to talk about what happens if someone has a major medical issue, for example, a diagnosis of cancer or something else in the job. what rights do they have moving forward, and whether or not accommodations, time off, et cetera, may apply. And I think Kyra can help us with that too.
Absolutely, we know she will be able to help us. And we also want to know that you can get help as well by reaching one of the attorneys at Hollis Wright. That number, 1-844-LAW-TALK, that's 1-844-529-8255. That call is free. That call is confidential. You can reach someone right now. They're standing by to take your call. We're not done yet. We're still talking about accommodations in the workplace, and we'll continue that discussion when the attorneys continue right after this.
Thank you for watching The Attorneys each Sunday night, where we come to your living room to provide free legal advice in a confidential, off-air setting. Unfortunately, with the number of calls, texts, and emails that come in during the show, we can't always get to everything. But know this, Hollis Wright is open all week long. You call us at 844-LAW-TALK and we're going to answer your question for free. Thank you for watching The Attorneys, and we look forward to seeing you and talking to you soon.
Did you know when you have to take a case all the way to trial, there is almost always insurance involved? Don't take on large insurance companies on your own. Our attorneys are standing by right now to give you a free consultation. At Hollis Wright, your result matters.
Welcome back to The Attorneys. Got questions? Guess what? We've got answers, and you can get those answers at 1-844-LAW-TALK. And we also have answers right here as we're talking about accommodations in the workplace with Kyra Fontenot.
So when we were going to break, one of the things I wanted to talk about is, what if someone has a major medical issue that hits them, whether it's a heart attack, a diagnosis for cancer, something, and it may not even be them, it may be a family member that they need to be with. How is that managed? Does the law protect certain circumstances like that?
Yes, if you work for an employer that has more than 50 employees in a 75-mile radius, you can qualify for FMLA protection. That's the Family and Medical Leave Act. And if you've worked there for more than a year and you've had 1,250 hours of work that's basically part-time, you can request time off for work. And this isn't one of the cases where you don't actually have to make the explicit request. The employer has to offer it to you.
So, and what is the benefit that you get if you fall into that category? Is it that your job is maintained for a certain period of time, but they don't have to pay you, or do they have to pay you for a certain amount of time when you're off? How does that work generally?
So under the FMLA, you're entitled to 12 weeks of unpaid leave, and that leave can be taken all in one block or intermittently. Let's say you have a spouse who has doctor's appointments for cancer. You can take half days. You can take full days. And you don't have to take 12 full days in a row, or not. You could take one day this week, one day next week, until all of your leave time is exhausted. But it's not required to be paid.
Yeah, that's just good information for people to understand.
It is, and viewers at home, it probably dealing with something else, and that's harassment. Sometimes you deal with that in the workplace. What are your rights with that? How's that handled if there's harassment in the workplace?
Yeah, a lot of people think they're being harassed, but they're really being disciplined. So it's really important to understand what.
That's a fair point.
The distinction between harassment
I think my kids feel that way sometimes too.
Yeah, so people use harassment pretty loosely, but harassment is really a persistent or a severe treatment of a person that is based on one of the protected categories where they're being treated unfairly. And one of the ways that could be is they're using racial epithets about you. They're singling you out. They're touching you. If it's a lot of harassment claims involve a physical touching, so you might actually have like a battery involved. Harassment is not, they disciplined me because I kept coming in late, or my manager doesn't like me. Mm-hmm. It is conduct where they're following you around the workplace. face, or repeatedly using insensitive racial language or sexually explicit language around you that makes it difficult to do your job.
Talk to me a little bit about, in my area of the law, there are trends that I see that may be decade to decade trends. Things change over time, and certain things become more of a focus. What trends are you seeing in your area of the law now that, like, you're seeing more and more of these cases? Is it in the area of harassment? Is it in the area of accommodations required or discrimination? What do you see?
So we just came through the Me Too era, so that was a lot of harassment, a lot of people speaking up about how they're being treated at work. But right now, with pay equity is becoming much more important as people become more transparent about how they are being paid. It used to be that it was taboo to speak about your pay, but what we're finding out is when you do talk about your pay, you find out that someone else is getting paid more than you. And if you are a woman and men are getting paid more for you to do the same job, then there's protection for you. And the only way you're going to find that out most of the time is by talking about pay very transparently at work. And so pay equity is probably one of the things that are going to be on the rise.
And so in those cases, when you get involved, what information do you generally need? Do you need, for example, a handbook? Do you have to go to litigation quickly in order to be able to gather the pay disparity? Like, how do you gather that information?
So one thing with pay disparities is we can usually go back 2 years from the day that we complain about it at the EEOC. So, and we haven't talked about this, but it's very important that we have a very short timeline when we talk about employment law claims. You have 180 days from the discriminatory act to get to the EEOC and make claims known so that they're protected. But on a pay claim, then once you get to that 180 days, you go back 2 years of paychecks, at least 2 years of paychecks from there that you can recover from. But every paycheck you wait is one that falls off.
And I know that this goes without saying, but when someone comes to you, do you generally offer kind of an initial consultation to walk through it at no cost to evaluate their case?
Yes, we actually, our law firm staffs our intake line with lawyers, and sometimes we just give folks advice, and we'll say, hey, go back. Talk to the people at your job and complain and say this, use this buzzword so that you can get a better result. But the key in these cases is document, document, document. We're talking about things that it's always going to be a he said, she said. So follow it up with an email, record them. Make sure that there is a record of the events the way you said it, because when we get into depositions I sue them, they're going to say, oh no, that never happened.
Well, in the time frame, like 180 days, that's tight.
It is tight.
We don't see that in the area that I practice in, because generally it's 1 year to 2 years, so that time frame is critically important too.
And hopefully this is a quick answer here. You mentioned the FMLA, the Family Leave and Medical Leave Act. Who qualifies for that?
Everybody who works for an employer that's more than 50 employees in a 75-mile radius and who has worked more than 1,250 hours in the previous 12 months and has been there for at least a year.
And that's really not a lot of time when you think about it. I mean, that's really only part-time for an individual that still could qualify under that. You've done a great job, and I mean, like, this area of the law can be complicated, and so I got your cases coming. Don't you worry about that, and I mean that. You do a great area in this area of the law.
As Kyra Fontenot and Josh Wright, we want to thank you for joining us here on The Attorneys. We are back next week, same place, same station, right here for another edition of The Attorneys. Have a good one.
Thanks for watching The Attorneys, sponsored by Hollis Wright.